Supplementary list for motion item A.
Similar thing. Withdrawn.
Not your worship. Worship, the notice has been withdrawn. Worship, I have instruction.
Heard Mr. B. Sinhala, counsel for the writ petitioner. Also heard Ms. N. Bordoloi, learned standing counsel in Revenue and Disaster Management Department, Assam, appearing for the official respondent, who had produced a copy of the written instruction dated 11/10/2022, issued by the Circle Officer, Guwahati Revenue Circle, to submit that
Put one.
the eviction notice issued to the petitioner dated 22/9/2023 has been cancelled by memo number 11, memo dated 11/10/2023.
No, your lordship, memo number GC 27/2014.
G full stop C full stop 27/2014/3060.
Dated 11/10.
Dated 11/10/2023. If that is so, nothing survives for adjudication in the writ petition. Therefore, retaining a copy of the written instruction dated 11/10/2022 in the record of this case, the writ petition stands closed as infraction.
I'm obliged, your worship.
Daily list for admission item 1.
My learned friend has made a note, my lord. Facts of the case, reply and all. Note.
So this will require a full length hearing, is it?
Lordship, I do not
Otherwise-
think since this is a matter where the petitioner's relative is not traceable, Lordship. The constitutional court, Lordship, in its, it has got the power in view of the law laid down by the Supreme Court. In 2010 SCC, but there is a question of fundamental rights, irrespective of whether the law allows or not, the court can.
My lord, I have given a small note, my lord, including, my lord, the case laws. And the relevant is 2010. My lord, 2010, yes.
2010 SCC 571.
And other even 2021 15 SCC, I made a note like this one. Maybe in short, my lord, what has happened, my lord? On,
No, let us hear.
yes, that brief facts, your lordship will kindly see this note. This is the brief facts, my lord. It's very small. After some time, they have constituted an SIT. There also no result was given. So therefore, my lord, this petitioner did not get any relief. And the persons who were arrested, their wife, they have been given appointment in council. Affidavit contention, your lordship will kindly see.
Just a minute.
PSC कितना है? भाई, Five. 46. उसको दे दे। Yes. So the facts will clearly show, my lord, 2016, my lord, police investigated. Then thereafter, they were not happy with their own investigation. Ultimately, SIT was constitution. Court recorded that even the SIT investigation is not a happy one. And all the accused persons who were arrested and who were released, one of their wives are working, the connection with the CM, Chief Executive Member of the Council. So this is a political matter, my lord. So therefore, it will not steal confidence in the people, my lord. Since 2016, my lord, even the persons who have telephoned, he has also not been, but they are saying that he is roaming in the town freely. So in that situation, my lord, the lordship will kindly see 2115 SCC 777. And the kidnapping, your lordship knows it is because of prohibiting that he should not participate in the no confidence motion. I have given a small note, my lord. So that, but I can read this paragraph 27. This is the latest one. Flag A, my lord. In the facts of this case, the charge sheet which is dated so and so has been submitted to the competent court on so and so. The submissions of the charge sheet does not host the jurisdiction of a superior court when, as in the present case, the investigation is tainted and there is a real likelihood of justice being deflected. The court held that whenever a charge sheet has been submitted to the court, even this court would not ordinarily reopen the investigation, especially by entrusting to a specialized agency. However, in a proper case, when the court feels that the investigation by the police has not been in proper perspective and that in order to do complete justice, where the facts of the case demand that the investigation be handed over to a specialized agency, a superior court is not bereft of the authority to do so. Similarly, paragraph 28, my lord, while quoting other judgments, my lord. And 29. Thirty, 31, my lord. Paragraph 30, my lord. Having regard to the circumstances which have emerged on the record, which have been adverted to in the earlier part of the judgment, we are of the view that it is necessary to entrust the further investigation of the case to CBI in exercise of the power under 142. The conduct of the investigation authorities from the stage of arriving at the scene of occurrence to filing of the charge sheet do not inspire confidence in the robustness of the process. So ultimately, my lord, confidence of the court matters, my lord. Whether court is confident, whether the person is getting justice or there is likelihood of getting justice. And the persons who were arrested Monday only after filing of the writ petition, not before that. They were just sleeping over the minor matter. Flag B and C is, my lord, on the materials on record, court can see whether CBI inquiry given. But I find, my lord, the Madurai case also, my lord, at flag B, it says, my lord, can be allowed only in exceptional cases when investigation of police does not inspire confidence on account of external influence or otherwise. And flag E is the division bench judgment of the Madurai court, Madras court, my lord. It says, my lord, in para 12, as there is need for instilling faith of the public at large and having regard to the gravity and political nature of criminal nature of the case, directed for CBI inquiry. Yes.
Lordship had directed me to take
Other
instructions.
judgment is there 2010. Yes, same context.
Here the Lordship CBI says that it is unable to take up the subject case due to resource crunch. Lordship, resource crunch cannot be a obstacle in the Lordship delivery of the justice system. Lordship would definitely not go by it. Resource crunch, Lordship, if they do not have the resources, it is for them to have their resources. Now, so far as Lordship, the citations given by my senior friend, coupled with that, Lordship, 2010 3 SCC 571, this is a constitution bench judgment. Lordship, I'll give a copy, but I'll just read out, Lordship. Here, the question was whether the court can direct for a CBI inquiry where there is a provision in the act that the consent of the concerned state has to be taken. I'll just read out part of the conclusion, that is paragraph 45, subpara 7. Supreme Court says when the Special Police Act itself provides that subject to consent of the state, the CBI can take up investigation in relation to the crime, which was otherwise within the jurisdiction of the state police. The court can also exercise its constitutional power of judicial review and direct the CBI to take up the investigation within the jurisdiction of the state. The power of the High Court under Article 226 of the Constitution cannot be taken away, curtailed, or diluted by Section 6 of the Special Police Act, that is taking the consent of the state. Irrespective of there being any statutory provision acting as a restriction on the powers of the court, the restriction imposed by Section 6 of the Special Police Act on the powers of the Union cannot be read as restriction on the powers of the constitutional courts. Therefore, the exercise of power of judicial review by the High Court, in our opinion, would not amount to infringement of either the doctrine of separation of power or the federal structure. In the final analysis, our answer to the question referred to is that a direction by the High Court in exercise of its jurisdiction under Article 226 of the Constitution to the CBI to investigate a cognizable offense alleged to have been committed within the territory of the state without the consent of that state will neither impinge upon the federal structure of the Constitution nor violate the doctrine of separation of power and shall be valid in law. Being the protectors of civil liberties of the citizens, this court and the high courts have not only the power and jurisdiction, but also an obligation to protect the fundamental rights guaranteed by Part 3 in general and Article 21 of the Constitution in particular, jealously and vigilantly. But however, it adds a word of caution. Before parting with the case, we deem it necessary to emphasize that despite the powers conferred by Article 32 and 226 of the Constitution, while passing any order, the courts must bear in mind certain self-imposed limitations on the exercise of these constitutional powers. The very plenitude of the powers under the said articles require great caution in its exercise. Insofar as the question of issuing a direction to the CBI to conduct investigation in a case is concerned, although no inflexible guidelines can be laid down to decide whether or not such power should be exercised, but time and again it has been reiterated that such an order is not to be passed as a matter of routine or merely because a party has leveled some allegation against the local police. This extraordinary power must be exercised sparingly, cautiously, and in exceptional situations where it becomes necessary to provide credibility and instill confidence in investigations, or where the incident may have national and international ramifications, or where such an order may be necessary for doing complete justice and enforcing the fundamental rights. So here is a case, Lordship, from the pleaded case, and of course I have not seen the report of the SIT, Lordship. It has not progressed anywhere, Lordship. Therefore, Lordship, to instill that confidence in the common citizens, perhaps it is necessary, Lordship. Lordship, it's in the rough paper, Lordship. Oh no, flag columns.
Get this judgment. 2010 3 SCC 571. All right, so then the matter has to go to the CBI.
Lordship, perhaps, Lordship, without going into the,
So now what will be the operative part if the court directs that CBI should conduct inquiry?
Lordship, it has to be taken up from the stage of this report of the SIT, Lordship, that earlier
That
part.
we
has al-
can't say. They have to carry out investigation
Lordship,
in connection with so-and-so case. But how CBI will go and take it over, or somebody needs to do something?
no, it has to be handed over to the CBI by the state police, Lordship. Whatever records they have, Lordship.
Hmm. And some notification is required to be issued?
When there is an order of the court, not Lordship.
All right. Take down, Mr. D.D. Das, Learned Senior Counsel, assisted by Mr. D. Thousand, Learned Counsel appearing for the writ petitioner. Also heard Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General of India, appearing for the CBI authorities, bracket respondent number 4. The respondent number 4, is it?
Lordship, yes.
Mr. S. Borua, Learned Government Advocate Assam, is present on behalf of the respondent numbers 1, 2, and 3. Take down. The writ petitioner herein is the wife of Jibon Kamprai, who was kidnapped by some miscreants on in the year when did the kidnapping take place? 28/1/2016.
27.
On 27/1/2016. From Dayangmukh, DIYUNG in the Dima Hasao district of Assam. First up, an FIR was lodged based on which Dayangmukh PS case number 03/2016 was registered under section 365/506/34 of the IPC. Unidentified miscreants, right? In the FIR, it has been clearly mentioned that the kidnappers had earlier threatened Sri Mahendra Kamprai, that is the brother of Jibon Kamprai. Now, the kidnappers had earlier threatened Sri Jibon Kamprai, asking his brother should abstain, is it? Asking his brother, Sri Mahendra Kamprai, to abstain from participating in the emergent meeting of the N full stop C full stop Hills Autonomous Council held on 19/1/2016. As otherwise, he would face dire consequences. First,
It was fixed for no confidence motion.
it appears that it was fixed on 19/1 or 29/1.
29/1/16.
When was the meeting fixed?
29/1/16.
Acha,
And it was for no
29/1,
confidence motion.
2016. But he was kidnapped before the meeting was held.
Yes.
Huh?
Yes. Yes. That was the purpose, that don't allow your brother to attend the meeting.
At 29/1/2016. It has been alleged that so as to prevent Mohendra Kamprai from participating in the emergent meeting scheduled on 29/1/2016, wherein a no confidence motion was to be discussed. No confidence motion brought against the executives in power in the Autonomous Council was to be discussed. Full stop. However, since then, the whereabouts of Jibon Kamprai has remained unknown. Full stop. Initially, the Assam police had conducted investigation in connection with Dayangmukh PS case number 03/2016, but could not make any headway in the process. Full stop. As such, the wife of the missing individual, namely the present petitioner, had to approach this court by filing the instant writ petition, seeking a direction from this court to hand over the investigation to the Central Bureau of Investigation, bracket CBI. That is the respond number 4, full stop. It appears that during the pendency of this writ petition, a 3-member special investigation team, bracket SIT, bracket close, headed by the Superintendent of Police, Dima Hasao District, had taken over the investigation in connection with Dayangmukh PS case number 03/2016. As such, a report was called for by the court from the SIT as regards the progress made in the investigation. First up. Accordingly, on 03/08/2023, the Superintendent of Police, Dima Hasao District, Haflong, had submitted a report in a seal cover. Full stop. After perusing the report, it transpired that Seven, except making a few arrests and recording statement of few other witnesses, the SIT also could not make much headway nor conclude the investigation, as a result of which no charge sheet has been filed in connection with Dayangmukh police case number 03/2016 till today. First up. The whereabouts of the victim. No, you're right. The victim remains untraced till today. That is, even after more than 7 years since his disappearance, and there is no clue as to whether he is still alive, or there is no clue as to whether he is still alive. Full stop. It is under these circumstances, the petitioner's counsel has renewed the prayer for handing over the investigation to the respond number 4. Full stop. Mr. Das, that is senior counsel for the writ petitioner, has vehemently argued that this is a clear case of political assassination, and the said facts would be apparent from the fact that after the release of the 6 arrested persons, their wives had been appointed in different departments of the council, and the main suspect is roaming freely within the Haflung town without any effort from the police to nab him. Mr. Das submits that even the wives of the 3 main suspects have been given jobs, and the person who had made the phone call to Mahendra Kemprai before kidnapping the petitioner's husband has neither been arrested nor interrogated till today. Full stop. Contending that neither the Assam police nor the SIT has been able to make any significant progress in the investigation, and therefore the present is a fit case where the investigation should be handed over to the police, to the CBI. Full stop. Mr. Das's father, Mr. Das's father argued that this is a clear case of violation of fundamental right to life of the petitioner's husband. And since the incident took place in a politically charged situation where there is direct evidence to suggest that the kidnapping was carried out for a political purpose, unless the matter is handed over to the Central Bureau of Investigation to a specialized agency, the petitioner would not get justice. Full stop. Mr. Das's father submitted that in order to secure the ends of justice and also in order to do complete justice and also to instill confidence in the mind of the public as regards the law enforcement agencies, it is necessary to hand over the investigation of this case to the CBI. Full stop. In support of his above arguments, Mr. Das has relied upon the recent decision of the Supreme Court rendered in the case of Dr. Naresh Kumar Mangla versus Anita Agarwal and others, 2021 (15 SCC 777). Then Sakiri Vasu versus State of UP and others, reported in 2007 (8 SCC 226). And Secretary Minor Irrigation and Rural Engineering Services, UP and others versus Sanguram Arya and others. Stop. Responding to the above, Mr. R.K. D. Chaudhary, learned DSGI, appearing for the respond number 4, submits that the CBI is reluctant to take over investigation in the case due to resource crunch. The learned DSGI has, however, submitted in his usual fairness that when it is a question of fundamental right to life of a citizen, and since there are allegations of political motive behind the incident, uh, the relief sought for in the writ petition cannot be denied merely on the ground of resource crunch. Full stop. Mr. N. Goswami, Mr. S. Burua, learned G. Assam submits that the state police has done whatever was possible, and despite the best efforts, no breakthrough could be achieved in the investigation. Full stop. That's your stand, or that's not your stand? That is your stand. Full stop. Next para. I have considered the submissions made at the bar and have also carefully gone through the materials available on record. Full stop. There is no dispute about the fact that the husband of the petitioner went missing on 27/1/2016, and prior to that, telephone calls were received by his elder brother Mahendra Kemprai. Phone call was received by Mahendra Kemprai or Jivan Kemprai?
Mahendra Company.
Telephone calls were received by Mahendra Kemprai, who was a member of
Autonomous Council, Malak, member of NCL's Autonomous Council.
the NC Hills Autonomous Council at the relevant point of time, threatening him to abstain from taking part in the meeting scheduled to be held on 29/1/2023, wherein a crucial agenda of removal of the party in power from office was to be discussed. First step. Since then, the whereabouts of the husband of the petitioner is unknown. First step. I also find from the materials available on record that not only the Assam police, but even the SIT constituted for carrying out investigation in connection with Dayan Mukh PS case number 03/2016 has failed to yield any result. And from the affidavit submitted by the respondent number
Number 3.
3, that is the Superintendent of Police, Dima Hasao District, as well as from the submission of the learned G. Assam, it appears highly improbable that any further progress is likely. Any further progress in the investigation is likely in this case. Situated thus, the only way forward in this case appears to be to hand over the investigation to a specialized agency such as the CBI. Full stop. In the case of Dr. Naresh Kumar Mangla, bracket Supra, the Supreme Court has observed that in order to do complete justice, where the facts of the case demand that the investigation be handed over to a specialized agency, a superior court is not bereft of the authority to do so. Stop. Again, in the case of Sakiri Vasu, bracket Supra, the Supreme Court has observed that after looking into the materials of the case, the High Court would have the power to order a CBI inquiry. First of, however, that such power should be exercised. Now, has observed that looking to that, the High Court has the power to order a CBI inquiry. However, full stop, however, such power should be exercised if the High Court, after considering the materials on record, comes to a conclusion that such material discloses prima facie, a case calling for investigation by the CBI or by any other similar agency. Full stop. A CBI inquiry cannot be ordered as a matter of routine or merely because the party makes some allegation. Full stop. In the present case, as noted above, this court clearly finds the probability of a political overtone in the incident, and considering the ground realities prevailing in the Dima Hasao district in Assam, and having regard to the shabby nature of investigation conducted in this case thus far, this court is left with no manner of doubt that by relying upon the state police, the petitioner would not get justice. Full stop. The facts and circumstances of the case clearly suggest that unless investigation is carried out by a specialized agency, such as the CBI, justice would not be done to the petitioner in this case. Full stop. In view of the above, this court is of the considered opinion that this matter deserves to be handed over to the CBI. Full stop. Since it is a question of life and liberty of citizen, and in view of the factual backdrop of the case, this court is unable to agree with the stand of the CBI that due to resource crunch, the matter should not be sent to the CBI for investigation. Next para. Coming to the other important question as to whether this court can directly hand over the matter to the CBI without obtaining the consent of the state of Assam. The aforesaid issue has been elaborately dealt with by the Supreme Court in the case of State of West Bengal and others versus Committee for Protection of Democratic Rights, West Bengal and others, reported in 2010 bracket close 3 SCC 571, and held that the power of the High Court, that the jurisdiction of the High Court under Article 226 of the Constitution to issue a direction to the CBI to investigate a cognizable offense alleged to have been committed within the territory of a state without the consent of the state will neither impinge upon the federal structure of the Constitution nor violate the doctrine of separation of power and shall be valid in law. Full stop. It was held that being the protectors of civil liberties of the citizen, the superior courts, including the high courts, would not only have the power and jurisdiction, but also an obligation to protect the fundamental rights guaranteed by Part 3 of the Constitution in general and under Article 21 of the Constitution in particular, zealously and vigilantly. For the reasons stated herein above, this writ petition succeeds and is hereby allowed. The respondent numbers 1, 2, and 3 are directed to ensure are directed to initiate all steps to hand over the investigation in connection with Dayang Mukh PS case number so and so to the respondent number 4, that is the CBI, by following the due process of law. Once the records are handed over to the respondent number 4, investigation be carried out and completed as expeditiously as possible, so as to bring the process to its logical end. With the above observation, this writ petition stands closed.
All right, sure.
Anything left? Anything else to be added?
Item
May it please your lordship. My lord, last week lordship heard the matter for a while. And basically the matter is on the same facts. The matter is covered by a judgment of our own High Court. One judgment, or one of, in fact, there were 3-4 judgments from Tripura High Court, division bench. And in one of those cases, my lord, FCI went on SLP and the Supreme Court also declared, my lord, the impugn action, which was similar, unsustainable. My lord, I will have to slightly, I think, refresh your lordship, my lord, and I'm sure your lordship will not take more than 6 to 8 minutes to recapture the facts, my lord. What is challenge is, my lord, absolutely unilateral, arbitrary series of orders by FCI deducting what is called, my lord, railway demurrage charge, not even following any prescribed procedure as prescribed, my lord. My lord, pursuant to NIT and being a most competitive bidder, I was appointed as handling and transport contractor by FCI for 2 years, commencing from, my lord, 21/11/21, which your lordship will find at page 29.
Yes.
It is written, my lord, appointment of handling and transport contract ex railway siding, Salapara, it's in the Porak Valley, my
No,
lord.
it is Salchapra, yes.
So I'm sorry, Salsapra to FSD Badarpur Ghat via way bridge, including handling at FSD Badarpur Ghat on a regular basis for 2 years. There are two things, from wagons to siding. The handling works have been entrusted to, admittedly, to some other handling contractor. Our handling is at the destination point. Handling and transportation.
This is a contractual matter, contractual bill.
Contractual.
Is this
Yes.
pertaining to this bench?
No, my lord,
Then why? huh?
your lordship fixed it, my lord, that the hearing.
No,
What
on the
about-
last occasion also, no hearing was taken place.
Don't avoid, please. His
No, I'm
lordship,
ready.
it is for his lordship.
No, I'm ready.
Lordship, last occasion, your lordship heard it for about.
Yeah,
50.
just.
Yes. Your lordship, last occasion, last year, your lordship fixed it, my lord, today.
Anyway, both parties are ready. I'll
Yes,
just
yes, my, that's what I am saying. Courts are good.
call the register.
So, my lord, the handling, this was the contract, my lord, 8/11/2021
Not
for
now,
2
not
years.
now, not now. Yes.
And obviously, my lord, it is going to expire in coming, my lord, 7th of November. After vacation. Contract will come to an end. Now, my lord, we started working, commenced work, my lord, immediate effect. And till that, my lord, I have been successfully transporting all assigned food stuff from railway heads to FSD. Neither any complaint or dispute, my lord, with regard to handling and transportation. almost, but right from the beginning, my lord, FCI is unilaterally doing one thing without notice and most illegally. They are deducting considerable amounts from almost every bill purportedly as demerit charge. Now, what the demerit charge is all about? It is charge inflicted by the railway for late opening of wagons and receipt of goods from wagons. And there are existing railway circular which, my lord, governs this, which your lordship will find at page 37, 38, annex of 5.
Page
Page-
37, 38.
Yes, page 37, lordship may come below, my lord. 2.5, free time for loading oblique unloading of various types of blocks, rakes. In the case of freight, terminal, siding, it is Salasapra siding, my lord. Still, so and so, so and so, so and so. Now your lordship see the columns. Free time, 3 hours, 3 hours, 3 hours. Unloading 5 hours, 2 hours. For a rake, for an open rake, for a tank rake, for a flat rake, etc. Now, next page. Your lordship will have a look at 3.0, rates of demerit charge. Rates of demerit. Demerit charge shall be levied at the rate of 150 per 8-wheel wagon per hour or on part of an hour for detention of wagon in excess of the permissible free time for loading and unloading. The demerit of charges prescribed above shall be applicable equally to all types of 8-wheel goods wagons and coaching vehicles, irrespective of their carrying capacities. Rates of demerit charge in respect of 4-wheel wagons shall be half of the rates prescribed. Then 3.4.2 minor below. The rates can be increased by say 2 times or 3 times or so on, and not necessarily 6 times at one go in all cases. In fact, railway may decide to levy variable rates like 2 times for the first time, first 3 hours, 3 times for the next 12 hours, depends on and so on and so forth. So, my lord, with respect to every consignment, FCI almost 24 hours, suppose tomorrow evening the rake is coming to Salasapra. There, my lord, give an internal communication which copy to me, which is called an indent. And one such indent is like, my lord, the one at page 31.
After that is not.
Page 31.
Page 31, lordship. This is the type of indent they issue. Lordship may have a look. It is, my lord, to the railhead in charge from the movement manager of the district. Indent of allotment of wagons for so-and-so rake, so-and-so rope containing 58 wagons. This is a communication between, my lord, FCI's own officials with copy to the contractor below. Here in the box you will find, lordship, petitioner, Badarpur Ghat, high speed logistics. This is me, my lord. Given 15 wagons of food grains. Below the copy, lordship, is the manager, depot in charge, FSD, Ramnagar, Lala Bazar, Badarpur Ghat, Nilam Bazar requested to take appropriate measure for speedy release of the loaded trucks. It is also requested to ensure submission of all necessary correspondent documents relating to unloading within the stipulated time. Then RTC and handling road transport and handling transport contractor. It is requested to make necessary arrangement for positioning adequate man machinery for release of rake within 3 hours. Kindly to be in touch with said in charge. Said in charge are so-and-so, 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 Ramnagar, my lord. Lordship will find the East was issued on 38/22, and in the information it was written that allotment of 58 wagons. Now, what happened, my lord? The problem is we remain in touch with FCI, and my lord, we also immediately give, my lord, our reply about placement of trucks, like one at page 47, lordship.
Page 37.
Page 47. নহয় ইফালে হ'ব আৰু কোনটো সেইটো কিমান আছে 47 of the read is an extra 10 my lord. ওলাই দিয়াচোন ওলাই দিয়া This is from us, my lord, High Speed Logistics Limited. Yes. On 22nd of 8, 2022, we have informed the Divisional Manager of Food Corporation of India. Subject information regarding details of start of operation of transportation wheat bags via truck from Salapara to so and so, dated so and so, 22/8/2022 8 AM hours and completion of transportation so and so. And below your lordship will find that this is reference to above subject matter. We give the detailed particulars of all the trucks which we have already placed at the siding. 1 day before arrival. And my lord, these are matters of record and about placement of trucks well in advance by me. Now, my lord, normally, as your lordship knows, the goods train arrive during night hours. Normally, passengers trains are given the priority after 9 o'clock, 11 o'clock, even at 12 o'clock. Here also in the BG yard, Bamuni Maidan. As soon as, my lord, the train with wagon arrives at the station, we as a transporter cannot directly receive the goods from railway. They are the consignee, FCI, not we. Even the handling contractor at the rail yard also cannot receive the goods directly from the. Now, what happened? There ought to be, and there is supposed to be under the terms, my lord, one representative from FCI has to be there in the yard as the receiver of the goods. But perhaps, my lord, the babus that they don't come at 12 o'clock. They come leisurely next morning at 10 o'clock. This is the, my lord, actual factual ground, and I have made an amendment to that. Now, my lord, lordship will kindly see FCI personnel has to be there at the railhead with consignment. Why? Because wagons come with seal and lock. There is seal, everyone. It has to be inspected jointly by the railways. I have made my lord railways a pro forma defendant here, respondent here. They are not answerable. So they are just FCI's personnel has to be there. Self seal of wagon is first, my lord, inspected jointly by railway and FCI personnel. Documents submitted by FCI to railways concerned. Details are entered into registers maintained both by the railways and by the FCI. One cannot suddenly upload. So there are formalities. Then the wagon doors are open, unloading from wagon and loading on the trucks. Captain, my lord, the process starts. Then it goes to the weighbridge as a transporter, my lord. It is written in my terms of appointment, my lord, via weighbridge at page 32. So because of, my lord, the stranded wagons beyond 3, 4, 5, 6 hours of free time, railway imposes, my lord, demurrage charges on FCI. And FCI, my lord, in a very routine, unilateral manner, my lord, puts the buck on us. Simply they deduct that amount from my transportation fee. That is basically the factual situation, my lord. And they cannot do that. So till the time of filing of this case, my lord, there was an interim order, but they bypassed it. I will come to that. Till around the time of filing, 64 lakhs of deduction charges have been deducted from my bills. By now, standing on today, my lord, my instruction is plus 1.5 crores. Almost 2 crores deduction. So how can I, my lord, public contractor survive? My lord, now the question is, apart from all arbitrariness, unilateral sanctions orders, unabated deductions, the demerit charges are also without jurisdiction and authority. This is what our High Court has decided. By the my Lord Lordship may kindly have a look at page 44. Yeah. Page 44, my Lord, Annex 8.
Yes.
This is one, my Lord Lordship may see, this is one such sanction orders, 2/2/2022. Below it is, kindly see, it is issued by manager accounts. Manager accounts. It is from the district office Silchar. So there is a district officer now redesignated as my Lord divisional manager. Below post is my Lord manager accounts. In fact, in any district office, there are 3-4 manager accounts. It is one of them. He has written, sanction is accorded for payment of the following transportation bill in respect of so-and-so transportation food grains, bags, so-and-so. The manager accounts FCI DO Silchar is requested to make payment after thoroughly checking verification of the bills and deduction of demurrage liability. Now the bill period, box in the box, second column, bill period, it is written, gross amount of bill, that was 6,14,571. This is just from one bill. Then, my Lord, income tax, that is normal deduction. No dispute about that. Then DC is demurrage charge, 63,730. Now, this is without jurisdiction. This officer cannot, because Lordship is, it is quoted at my Lord, paragraph 20, page 16 of the writ petition.
Yes.
That among all other requirements, obligations between the parties, so and so, it is also spelled out as the contractual mandate which is required with regard to demurrage in subclause 21 of clause 10 of the model tender form. Now it is quoted below. The contractor shall be responsible for unloading, loading the wagons within the free period allowed by the railway, and also for loading, unloading, so and so, so and so, so and so. The contractor shall be liable to make good any compensation, demurrage, wharfage, as per railway rules in force, that is beyond free time, or other charges or expense that may be incurred by the corporation on account of delays in loading, unloading of trucks, carts, and loading wagons, unless the delay is for reasons beyond the contractor's contract. Now it says, by may be incurred by on account of delay. Here, my Lord, it is the first receiver from FCI at the rail yard is the handling contractor. And in their affidavit, they have clearly stated that for that purpose, a separate handler is there. He has named it. I will not show it. Then it says, the decision of the general manager in this respect shall be final and binding on it. This is the crucial sentence. This shows who has got the authority. One is infliction. Even the general manager also cannot inflict, my Lord, any demurrage charge penalty without following the due procedure. He will also have to, my Lord. He is the authority, yes. Now, in this case, my Lord, Lordship, kindly see, I have already shown, it was by the accounts manager. Nowhere it is reflected that since I am in receipt of sanction order decided by the regional manager, now regional manager is called general manager, my Lord, redesignated. Nowhere. Lordship, may kindly have a look again at page. Sorry, I'm petition. the order. Thanks for page 45. Yeah, to let it. Here your lordship will find. No, it is 45, 45. Sanction order here, my lordship will clearly find what is written. It says sanction order. It says sanction order. Sanction is accorded for demise deduction. It is by district officer Silchar, Prabandhak, Anubandha, Mandal Karyalaya means district, my lord, Silchar. Here, my lord, I will refer to a judgment of this High Court, my lord. Bulbul. Bulbul did yes. Photocopy. Photocopy.
Yes.
I think for lordships, the copies were already there.
What is the name of the party?
My lord, the Bulbul Enterprise.
Yes.
My lord, it was a judgment delivered by my lord Honorable Justice Biswas here. Here, my lord, kindly see, I am reading, my lord, the paragraph to starting point. The court by order dated passed in so and so responding interim measure not to deduct the amount of so and so. There was an interim order not to deduct. Here also, my lord, on day one, it was said, but they use a different word. They say we are not deducting, we are retaining it. We are us. Take your handling with us. And minus this amount, take your transportation bills. So that was. Then, my lord, lordship, kindly come to next page. Although it was a 2090, 2000, year 2000, so kindly see the clause was all same. 12. Liability of contractors for losses, etc., suffered by corporation, the same language. Last sentence, the decision of senior regional manager. At that time, my lord, Assam region, there was the senior regional manager. Now it is general manager. The redesignation. Senior manager regarding such failure of contractors and their liability for losses, etc., suffered by corporations shall be fined. Now, paragraph 5 is important. I have perused the terms of the contract. Nowhere it is paragraph 5. Nowhere it is provided for any interim payment on deduction of demurrage charge before the liability of the contractor is ascertained by the senior regional manager as per terms of clause 12. Therefore, such deduction on the face of it appears to be in violation of the terms embodied in clause 12. The argument that deductions are proposed to be made from interim payments to raise sufficient security to liquidate demurrage charge that may be equally raised by the railway authorities. But the pleadings on record show that the petitioners has already given sufficient security for carriage of the goods. Therefore, corporation obviously cannot insist for additional security to be raised by way of deduction of demurrage charges in violation of terms. It can safely be concluded that proposed action of the corporation is not permissible under the terms of the contract. In my considered opinion, the proposed action of the corporation to deduct the demurrage charges before a decision in this regard given by senior regional manager is not sustainable. So without authority and jurisdiction at that point. Then my lord, paragraph 9, paragraph 10, certain Supreme Court cases of all Supreme Court cases were discussed, and then ultimately in paragraph 12, paragraph 11, my lord. Here next we can do later. Next to Talapatra. It would appear after discussing the ratios of Supreme Court judgments, my lord, this court said, it would appear from the above that non-arbitrariness is the essential concomitant of the rule of law, and that all actions of public functionary in whatever sphere must be guided by reason. It is clear from the above that exercise of a power must be for public good instead of being an abuse of the same, and the exercise of powers of such straight instrumentality emanating from the terms of the contract cannot be placed beyond the purview of judicial scrutiny. This being the law in force as on today, the arbitrary action of the respondents herein contrary to the terms of contract cannot be allowed to continue. Since such a direction is possible in the instant case without delaying deep into the disputed matters. There were also FCI raised certain disputes. No, he failed. There was his mistakes also at times and all these things. The court said this is jurisdictional matter. In the result, is possible in the instant case without delaying deep into the contention of Sri Dev that the court should not exercise its power under 26 in the instant case has to be rejected. In the result, writ petition allowed. Respondents are directed to act in strict compliance with the provisions of the terms and not to deduct any amount on account of demurrage without undergoing an exercise as provided. Then, my lord, there is the next case, your lordship will see. This is also, my lord, this is by my lord, the case I have just now read, Justice from this court, this High Court judgment. And this is from Tripura, my lord. Next case, Bimolendu Roy. It was by my lord, Honorable Justice Talapatra. Your lordship knows he was initially here. Then after Tripura became an independent High Court of Judication, Talapatra was still then here. It was his lordship judgment. Here again, can it turn to paragraph 3. Short regime of facts relevant in the writ petition is that petitioner is a contractor working with respondents for some years and transporting good grains from railway siding FSD, Dharmanagar to FCI Godown, Nandanagar. Petitioner was favored with the contract. When the petitioner had submitted the running bills for transportation in terms of said contract, collectively annexed, the respondents deducted the demurrage charge while paying against the running bills. According to the petitioner, respondents are not entitled under the said contract to deduct any amount on account of purported demurrage from this bill in as much as there is no authority of such deduction within the provisions. Then it referred to one case, my lord, of Guwahati High Court earlier, Putul Shah, and then this Bulbul Enterprise, Justice Biswas's judgment. Then paragraph 5, the so-and-so learned counsel appearing for respondent FCI submitted that in terms of the previous judgment in Putul Shah, so-and-so, this writ may also be decided. In Bulbul Enterprise, High Court held that demurrage cannot be deducted without undergoing an exercise as provided in clause 12 of the contract. Clause 12 of the contract is similar to clause 10 of the agreement, which is relevant for this. Clause 12 of the contract has fallen for consideration before Guwahati High Court, has been reproduced in the report. Clause 10 of the contract as relevant in the is reproduced thereafter. My lord, here, clause 10, lordship see, clause 10, liability of contract and losses suffered. Last sentence, the decision of the general manager regarding such failure of contractor and the liability for losses, etc., suffered for compensation and the quantification of such losses. Here the procedure comes. Shall be final. Quantification means, my lord, lordship, you are deducting 2,50,000 from me. Why it is 2,50,000 and not 75,000? How do you quantify? There is a process, my lord. Even when with authority and jurisdiction, the general manager passes an order, sanction order of deduction, it has to be preceded by a process. Give me a notice that you have failed from this hour to this hour. And admittedly, at the station in the yard, my lord, they had different transport contract, different handling contract. My case is extreme. There is no, then my lord, paragraph 6, there is no substantive difference between the two provisions in two different contracts as defined by so. And lordship may skip it. Then 7, paragraph 7, it, my lord, discusses again, my lord, Bulbul Enterprise. Then paragraph 8. Paragraph 8. However, having regard to the submission made by counsel for the parties, writ petition is disposed of with the following direction. Respondents are prohibited from realizing demurrage from the running bills of the petitioner in terms of the said contract unless the demurrage is ascertained by due process on embarking on a proper exercise where the petitioner will have a room for having his say. Has your lordship got that paragraph? Nothing like this was done in my case. Only on consideration of his say, the demurrage can be ascertained. That apart, the amount has been realized so far on the purported provision said contract dated so and so shall be refunded to the petitioner. Unless, this is what I want. The amount so long deducted should be refunded to me unless the demurrage is ascertained by the respondents following process as indicated above within a period of 3 months. Consequently, respondents are restrained from realizing demurrage. It was ongoing contract, running bills and in future without ascertaining amounts to the respondents. Then, my lord, the next case was also from Tripura. Here, Abhijit Paul. It was 2012 case. By that time, my lord, in place of regional manager, at the time when my lord Justice Biswas passed the order, it was regional manager. Thereafter, at the time when Justice Talapatra disposed of, it was general manager, redesignated. Here also the same clause. Then paragraph 5. According to petitioner, in the present, no such provision has been incorporated, and as such petitioner doesn't have any contract with Mr. Then, my lord, lordship may come to paragraph 7. So and so, so Bhumik Lanet senior appearing on has submitted the action of the service. Lordship may come skip that sentence. As there is no contractual liability, such determination is bound to be arbitrary and colorable exercise of power. It is submission of the lawyer. The Bhumik Lanet Council has relied on the decision of Bulbul relied. Then said that it has been held at where it has been held at. Article is discretionary and it has to be invoked in consideration of the facts. Dispute centers around arbitrary unfair action. Court shall not refuse to invoke them. Then paragraph 8. Roundabout middle. However, it is well settled that even in absence of any agreement or contract, the petitioner may be held liable if it can be substantiated that negligence or dereliction of the petitioner, the respondents for the negligence or dereliction of the petitioner, the respondents have suffered loss in course of transportation. But for that purpose, there shall be an inquiry where the petitioner must have his say, or the respondent must take recourse to a procedure established by law for realizing damage, if any. Having also, the respondents are directed to either determine the damages following the due process of law or satisfying the requirements of the principal nacelle or by way of conciliation. Only in the event the petitioner may be asked to make good, otherwise not. In the result, paragraph 10, respondents are directed to assess the loss, if any, they have suffered at the hands of so and so, so and so, in the period of so and so. Else, the respondent shall refund the sum as deducted from the transportation. Now, my lord, the other judgment, your lordship need not go, all in the similar lines. Here, only one sentence I will refer, my lord. The next sentence, Nomita Paul. Paragraph 7. Paragraph 7. Thus, this court is in agreement with the submission made by Bhumik Senior Counsel that procedure has been followed by the respondent is entirely arbitrary and betrays the principle of natural justice. Hence, the action of the respondents is held unsustainable as arbitrary and for abuse. Respondents are therefore directed to determine liability petition on account of railway following a procedure which is transparent and coming to the principles of natural justice or by way of conciliation of following. Such exercise must be done. The entire deducted amount as recovered from the respondent bills petitioner shall be refunded to the petitioner within 3 months. Here, my lord, his lordship imposes 6% interest also in this case. So, my lord, against this judgment, they, my lord, went to the Supreme Court, and Supreme Court not only upheld the findings of Justice Biswas and findings of Talapatra, Supreme Court on its own gave an additional reason from its own how this is bad. This is my lord Monopatra, equivalent to. No, it is not in the AR or Supreme Court, it is Monopatra. It is 22, November 22 judgment, Food Corporation versus Abhijit Pal. That was the Abhijit Pal judgment, my lord, I have read. I had not, my lord, it is facts, Food Corporation India appellant herein to be so and so, so and so. The corporation empowered itself under clause 12A to recover damage, loss, surge, cost under other acts suffered during for the same. Short question arising for consideration is whether damages imposed on corporation by the railways can be in turn recovered by the corporation from the contractors as charges recoverable under 12A of the contract. In other words, does contractors' liability for charges, if any, include demurrages? The single judge and the division bench of the High Court of Tripura have held that demurrages cannot be recovered as a charge by the corporation. Then dismissing the appeal of FCI, court has said, number 1, paragraph 1 below. It is evident from the contractual provisions and also admissions of the corporation in written submissions that the task of loading and unloading food grains from railway wagons was not a part of the contract. Here, my lord, in my case particularly, immediately to receive the goods from the rail yard is not mine. That job has been entrusted to a transportation. Lordship may kindly have a look there. It's an admitted fact. Their affidavit FCIs. Extreme case, my lord. I was in all these cases, Tripura matters, the contractors were also handler at the receiving end. But here, that part was not there. I am handler only at the destination point. Lordship may kindly
So
see.
there is another entity which has to unload the goods from the wagons,
Yes.
is it?
Yes, handling transport.
Handling,
Handling transporter will have to, my lord, take the goods from the wagons.
yes.
Then they will carry those. They will carry those and load in the trucks.
So your client was required to pick it up from the wagons.
When the, my lord, handler puts it on my trucks,
Hmm.
my truck goes, my lord, to the way bridge via, and then. to
That's what
this-
I'm asking.
that
So
is-
there is another handler here.
Yes, the lordship, this one, paragraph 11 of FCI's affidavit in opposition. Kindly have a look. Paragraph 18. This affidavit is dated, my lord, I think, 9/12/22. Yes. This is the affidavit in opposition on behalf of respondent number 1, 2, 3, 4.
Yes.
That's it.
Paragraph,
Paragraph, my lord, 18. That with regard to statements made in paragraph 6, I alleged there. I say that it is true that handling of food grains in railway siding Salsapra is done by a handling contractor, namely Onu Trade and Transport Private Limited, different, not me. However, the petitioner is the transport contractor of ex-railway sidings, Salsapra to Badarpur Ghat, including handling at Badarpur Ghat, destination point. So this is admitted position, my lord. Then coming back to the Supreme Court judgment.
so you are the handling contractor for the other end,
Other end,
that is the
Destination.
SSC,
destination.
but
point.
not in the railway siding.
This is what they have said. This is an extreme case, my lord. And I have been made responsible. I am not the first receiver to receive it beyond railway free time or before railway free time. First receiver is my lord FCI. In their presence, those will, I have narrated all these things. Seals will have to be upon in presence of railway representative and FCI representative. They are the concern, not me. I cannot directly receive, nor even the handler can directly receive. It has to be opened first by the railway representative and FCI and make note in the register. Give time. That yes, it is 11:35 PM. Detailed procedure. Now, my lord, coming back to the Supreme Court judgment.
Yes.
Here, my lord, I will refer paragraphs. Lordship may come to paragraph 2, 3. It says, my lord, paragraph 3. Present cases 12 discontinuous so and so having different. Then paragraph 5. 5. Contract was discharged. As this demand was, corporation called upon the contractor to reimburse the amount of damages imposed on it by the railways. Paragraph 5. As this demand was bereft of any reason and rightly objected to, it was followed by another letter dated so and so by the corporation. In this letter, corporation explained that it had incurred heavy loss on account of damage due to contractors' inability to readily provide trucks at railway, inhibiting the corporation from unloading food grains from railway wagons with the free time specified by the railways. The corporation sought to recover damages from the contractor by withholding the security deposit tendered under the work. Then paragraph 7, Lordship.
Yes.
Paragraph 7. This writ petition was allowed by single judge of High Court. It clarified that corporation was only entitled to recover losses that were incurred due to the contractor's dereliction of duties under the contractor as permissible under Section 73 of the Indian Contract Act, which provides for recovery of damages for breach of a contract. This would not permit the recovery of losses that were casually distant from the contractor's actions. Further, it is held that corporation has unilaterally determined and imposed damage on the petitioner and directed it to settle its claims through a civil suit recovery. The corporation filed writ appeal and the division bench of the High Court by order dated so and so dismissed the same on the ground of delay. Anyway, the review petition was filed by the corporation was also dismissed. The present appeals are against the orders in the writ appeals as well as review. Then paragraph. I think your lordship is going to take.
Just 5 minutes.
I also.
You have the records?
Yeah, get one. It is there.
Now analysis, my lord. This is court's analysis. Paragraph 16. The core question arising for our consideration is whether the contractual clause enabling the corporation to recover charges includes the recovery of damages. It is pertinent to extract the relevant clauses of the road transport contract, that is work order. The clauses detailing description, work, liability, and the power to recover losses, which are identical in all these three appeals before us, read as under. Brief description. 1. Transportation of food grains from depots, mandis, railheads of so-and-so to various destinations as per appendix. 10. Liability of the contractor. Here, my lord, the same clause 10 is quoted. Then clause 12 is also quoted. Then, my lord, paragraph 17. Corporation seeks to recover damages as a part of charges provided under clause 12A as extracted herein above. Expression charge that stand alone is not amenable to a precise meaning. Its dictionary meaning is open textured, definitely defining charge as any consideration that one must pay for goods and services provided. Therefore, the scope of expression charge must be understood as intended by the parties to the contract. The process of interpretation, though the exclusive domain of the court, inherits the duty to decipher the meaning attributed to the contractual terms by the parties to the contract. It is with this purpose that we shall now proceed to understand the meaning of the expression charges. Now, my lord, lordship may go to paragraph 23. The preamble of the contract, that is work order, reads that the contractor is engaged for transportation of food grains from depots, mandis, railheads to various destinations as per appendix. Further, clause 13 of the work order dealing with responsibilities of the contractor to the extent relevant for our purpose. I'm pausing here for a moment. The Tripura High Courts and our own Honorable Justice Bishnas's judgment, his judgment never, my lord, referred to this clause number 13. Discuss clause 10 and 11, which we are dealing. Supreme Court, my lord, went on and referred to this and quoted, in fact, 13, responsibilities of the contractor. Contractor shall be responsible to supply adequate and sufficient number of trucks for desperate, no doubt, for goods gain and carrying out any other service under the contract in accordance with the instructions issued by general manager or an officer acting. The F is important. The contractor shall be responsible for the safety of the goods from the time they are loaded on their trucks. Relates until they have unloaded other destinations. So my basic responsibility actually starts not when the wagons arrived. It is after loading in my trucks, I am the custodian of the goods. Anything, any loss or anything is done, I am responsible, my lord, until I deposit them at the destination point. Now, we have 24. We have scanned the entire contract in addition to scrutinizing the provisions extracted above and seen that there is no contractual provision requiring contractors to undertake the task of loading and unloading food grains from the railway wagons. Exactly my case. This is confirmed by the written submissions on behalf of corporation where the imposition of demurrage is justified only for reason that contractor didn't provide adequate number of trucks near the railway sidings to enable the corporation to promptly hand over the food grains. Here in my case, my lord,
Yes.
recently, my lord, they gave two intimations to me that you have failed to produce sufficient number. These trucks that you have placed are not sufficient. And we replied, the reason. On a particular day, if necessary, I will refer to our reply. On a particular day, there was a Barak Valley bond. And on another particular day, the yard was so congested with my lord building materials and other materials that more than my lord 5-6 trucks, my lord 20 trucks couldn't enter. We explained that. In any case, these things have not been gone into and not necessary to go into, my lord, for the courts as discussed by the Supreme Court. The reason why, my lord, this is confirmed by the written submissions on behalf of their 24, where the imposition demurrage is justified only for the reason that contractor didn't provide adequate number of trucks near the railway sidings to enable the corporation to promptly hand over food grains to them to commence transportation. The relevant portion is extracted under. The reason why demurrage charges get levied during the performance of an road transport contract is on account of failure of the contractor to supply required number and even after prior intimation about placing the railway tracks, due to which the petitioner is unable to empty the wagons as the food grains are liable to get spoiled if they are unloaded onto the siding due to rain, etc. Sorry, man. Even after unloading, unless they are removed from the railway premises within the free time available, which is charged by the railway, failure to provide tracks leads to detention of wagons beyond. 25. We may note that there is a dispute about the availability of trucks for the transportation of food grains by the contractor. While the corporation asserts that trucks were not made available in numbers as well as in time, contractor denies the same, stating that their trucks were kept waiting at the corporation's food security depots. 26. Irrespective of the disputed fact, put aside all the disputes that you have raised here and here one and there one during the 2-year period. The real question is whether the contractors had any obligation towards loading and unloading of food grains from the railway wagons. It is evident from the contractual provisions and also the admissions of the corporation in written submissions that the task of loading or unloading of food grains from the railway wagon was not a part of the contract. Exactly mine, my lord. Thus, based on interpretation of the expression charges in the contractual context, we are of the opinion that it didn't include liability on account of demurrage. Consequently, the corporation cannot impose and collect demurrage from the contractors. 28. Applying the above referred principles to the present case, we will juxtapose the present contracts with similar but not identical contracts entered into by corporation to confirm our interpretation that the word charges in the contract is exclusive of liability, no liability for demurrages. Personally, we will examine then liability of the, it was quoted, this description of the word, it was in my appointment order also, the headline was given liability of the contractors, clause 12, for losses suffered by corporation. Yeah, my lord, I have already read it. Demurrage is included, demurrages, etc. 29. It is evident from the above that contracts delegating the responsibility of loading and unloading food grains from railway wagons as an integral part of the contract include a clear and distinctive clause for the imposition of liability inter alia on account of demurrages. It is not the case here. Evidently, the liability clause in this contract term, the handling and transport contracts is starkly distinct from the present road. What has distinguished it? We have every reason to believe 30 that the corporation statutorily obliged to procure and distribute food grains across the nation enters into contracts depending on the services it requires. These contracts naturally vary depending on the needs and purpose of the corporation with the aid of the provisions in handling and transport contract from 2010. It started from 2010, we are unable to understand the intention of the parties while entering into the present road transportation contracts, as the present contracts do not involve the task of loading and unloading. This is important. Food grains from railway wagons as a part of the contractor's responsibility. There is no clause enabling the recovery of demurrage from them by the corporation. Thus, our interpretation of the expression charged as exclusive of liability for demurrages stands confirmed. 31. Then the Supreme Court proceeded to examine yet another handling transport contract which was executed 7 years after the present contract in 2018. Here also the description is given and clause 10 is quoted, demurrage, and the last sentence, the decision of the general manager regarding such failure of the contractor and their liability for losses shall be final and binding on the contractor. 32. It is evident from the above that handling and transport contract from 2018 similarly involved the loading and unloading food grains from the railway wagons within the scope of contractors' duties, thereby necessitating the inclusion of demurrage as penalty for non-performance of contractual duties. Thus, the present road transport contract is distinct from the handling and transport, same like me, from 2018, as the responsibility of loading and unloading food grains from wagons is absent in the present contract. The dicto, my case. For this reason, the corporation in the present contract has chosen not to include the power to recover demurrages, and as such, the expression charges cannot be interpreted to include demurrages. In the light of foregoing conclusions, we are not inclined to adopt a textual approach for the interpretation of the contractual term, charges, and hence decision of this court in Raichan, supra, my lord, and trustees, supra, are of no aid, as they simply, earlier there were two decisions. The Supreme Court said no. No aid, as they simply describe demurrage as a charge. In a sense, the earlier two judgments were overruled. Demurrage is undoubtedly a charge. Wherever, however, such a textual understanding would not help us decipher the true and correct intention of the parties to the present contract. For these reasons, civil appeals arising out of so-and-so filed by the corporation are dismissed. The decision High Court Tripura review upheld. The decisions of High Court Tripura in writ appeals dated so-and-so is also upheld. We may clarify that our decision has no bearing on any other remedy available to the corporation, like the institution of a suit for recovery, if law enables them to go. You go for a money suit before the appropriate civil court. Insofar as civil appeals arising so-and-so, my lord, this is different, referred to in paragraph 9 here, already said. Respectively, set aside, the civil appeals stand allowed. It is different. So, my lord, this squarely covers the judgments of the High Courts, including Guwahati High Court and Tripura High Court, my lord. They decided, my lord, these judgments decided, my lord, the other infirmities and illegalities and the authority and jurisdiction. Here, my lord, Supreme Court went one step ahead and said that this is not even a charge. You come under the Contract Act. That way you cannot do that. One additional, my lord, finding was given by the Supreme Court. Now, my lord, the question is, we have to. Wait. One, my lord, first of all, this is not, my lord, the entire action is not sustainable. And the grounds of challenge to their action and the impugn, my lord, notice or whatever they call, my lord, sanction by the stand manager accounts are all without jurisdiction. And there are other grounds also in my petition. These are violative of 14, 16, 19. It is violative of your own model tender form containing the clause 10, clause 11, clause 12. And demerits is not here decided by the general manager. It has been decided and sanctioned by the no prior information or any notice was given and it was done unilaterally. Fixed DRS, violation of natural justice. Suppose you have the authority, you accounts manager, you have the authority. Or you the district manager, instead of the general manager of the region, suppose you have, assuming, even in that case, they must follow the procedure and they must give him a notice that you have delayed by so-and-so hours on so-and-so night. I am not the handler, even to the handler, if they have deducted from him. Because of this reason, now explain. Otherwise, we are going to impose the management. This is not done. This is absent, unilateral, and in a routine manner. Railway imposes damages from on them, and then they shift it on me, simply, entire amount. Then FCI's failure. For FCI's failure, it cannot shift burden on me and abuse the power. It is also not in public good, my lord. Secondly, apart from the authority and jurisdiction, natural justice, my lord, violation of model tender from my legal rights, the determination of liability without giving a say to the petitioner, it was given, my lord, in the Justice Talapatra's judgment, upheld by the Supreme Court now. Determination of, suppose I am at fault.
Yes.
On certain given days, suppose I am at fault. With that position, coming down to that position, I am submitting before your lordship. The determination of liability without giving a say to the petitioner is per se exploitative. And
This judgment in Abhijit Pal versus Food
Yes.
Corporation of India,
yes,
against this, the FCI had preferred an
yes,
appeal,
yes. Against that,
preferred an appeal,
yes, against that. my
writ
lord.
appeal.
Yes, exactly. It is written, my lord. Against that, the case number is given.
It's of Tripura High Court, my lord.
That's right. Was any writ appeal preferred against?
Yes,
it?
they preferred a writ appeal. That was also dismissed by division bench.
Then it was came to the Supreme Court,
Then-
that Abhijit Paul
Then
case.
Abhijit Pal, they went to, that is the
I
case.
will answer to it, man.
Then, my lord. So, how do you arrive at a certain amount? That it is for a particular night, a particular day, it is 1,27,000. Why not 27,000? Why not 67,000?
I've noted.
Yes,
it.
I have not
Yes.
said. Sorry. The infliction of penalty, my lord, without due process of law, and the nature of function clearly says, my lord, they are the consignee, and railway is the consignor. Then, my lord, lastly, the entire action is irrational action, unwarranted action, my lord, and discarded already by, my lord, the High Courts and the Supreme Court. I pray that your lordship may declare the impugn notice and deduction as illegal, direct them to refund within a time limit, and say don't deduct during the rest of my tenure. That's all.
Yes. Where are the contract agreements? Is it?
Yes,
part-
I have annexed, my lord.
I'm just coming from the other court, 2 minutes, my lord.
My lord, just small facts, how this works, my lord. FCI appoint a contractor, transport contractor and also appoint a handling contractor for handling the loading and unloading of the bags from the railway wagon. And it is also appointed in the FSD, that is food storage depot, my lord. In this case, my lord, Anup Trade was admittedly, we have admitted in our affidavit of opposition, Anup Trade was the handling contractor. His duty was to unload from the wagon and to load it to the trucks of the different contractor, my lord. There were 4 or 5 contractors in that siding, my lord. And if the contractor fails to unload in a particular free time given by the railway, then railway imposes the damages charges upon the FCI, and the FCI proportionately impose that damages charges to the different contractor according to their performance, my lord. So there is also a clauses in the contract between in the understanding between the railway and the FCI that we apply for the waiver also, giving certain plea that because of this there was a delay, and railway waive certain damage charges, and accordingly we also give this after receiving the waiver, we refunded to the concerned contractors, my lord. Now coming to the, my lord, MTF, my lord, which we have annexed. 3 clauses are important. Clause 10A, liability of the contractor for loss suffered by the FCI. And then clause 20, subclause 21, liable to make good any compensation of damage charges.
Which page?
My lord, I am coming to running page is 121, my lord.
Yes.
Page 121 down below, clause 10, liability of the contractors for losses, etc. suffered by the corporation. Clause A is important, my lord, relevant. The contractor shall be liable for all costs, damages, demurrages. Demurrages is important. Wharfage, forfeiture of wagon, registration on fees, charges, and expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any service under this contract, or breach of any terms thereof of his or his failure to carry out the work with a view to avoid incurrence of damages, etc. under this contract, or breach of any terms thereof, or his failure to carry out the work with a view to avoid incurrence of damages, etc. and for all damages or losses occasioned to the corporation due to any act, whether negligent or otherwise, of the contractor themselves or his employees, my lord. Then, my lord, page 132. I will refer only 3 clauses, my lord.
Yes.
It is 21, my lord. It comes under clause Roman 20, subclause 21, my lord.
There is a problem with the pagination. It's not matching. It is in page 133.
I'm sorry, my lord. Otherwise, it is page 86 of the affidavit in opposition. If I'm the contractor, may I read it, my lord? The
Yes.
contractor shall be responsible for unloading, loading the wagons within the free period allowed by the railways, and also for loading, unloading the trucks, carts, any other transport vehicles expeditiously. The contractor shall be liable to make good any compensation, damages, wharfage as per railway rules in force during the period of the contract, or other charges or expenses that may be incurred by the corporation on account of delays in loading, unloading of trucks, carts, loading, unloading of wagons, unless the delay is for the reasons beyond the contractor's control. The decision of the general manager in this respect shall be final and binding on the contractor. Then, my lord, again, next page, my lord, the clause 30. The
This
contractors,
is, this is clause 21 of
21
clause
of Roman 20.
Roman 20. Yes.
Then 30. The contractor,
Hmm.
the contractor shall be liable for the costs, damages, charges, and expenses suffered or incurred by the corporation due to the contractor's negligence and unworkmanlike performance of any service under this contract or breach of any terms thereof, or his failure to carry out the work with a view to avoid to avoid incurrence of damages, warfare, etc., and for all damages or losses occasioned to the corporation or in any particular to any property or plant belonging to the corporation due to any act, whether the negligence or otherwise of the contractor himself or his employees, my lord.
Right.
Then again, I will take your lordship to definition of the term general manager, page 70.
Page 17.
70 of the of my affidavit in opposition, running page 117 or 118.
Yes, definition of
General manager, term general manager under Roman 5.
yes.
The term general manager shall mean the general manager of Food Corporation of India under whose administrative jurisdiction, the depots, railheads to which the contract relates fall. The term general manager shall also include the area manager. Area manager means, my lord, that of the particular district office Silchar, my lord. And every other officer authorized for the time being to execute the works on behalf of the Food Corporation of India. So it is, my lord, clear that they are authorized, my lord, to act on behalf of the general manager. This MTF, this agreement provides not only to the area manager and other officers, my lord. Now, my lord, I will come to my paragraph 20 of affidavit in opposition. I will read 2-3 paragraphs, my lord. Paragraph
Paragraph 20.
And before that, paragraph 12, my lord, it is important, page 54. Running page 54, inner page 7 of my affidavit in opposition. That at the very outset, I say that whenever any wreck is arrived at RS Salchapara, wagons are being allotted to the contractors. When the wagons are not unloaded in the given free time, the railway imposes fine in the form of demurrage charges for the time taken in excess of the applicable railway free time in releasing the rake. During the period with effect from November 2021 till August 2022, total amount of rupees 3,43,52,250 has been incurred as demurrage charges for food grains rakes placed at Salchapara under the FCI district office Silchar. It was mainly due to the late supply of adequate number of trucks, laborers by various handling contractors based on their performance. It may be pertinent to mention herein that if any waiver is received from the railways, the same is being refunded to the concerned contractors proportionately as per its earlier deduction after adjusting demurrage charges, if any, taken on FCI account. For the period from November 2021, the refund to various handling contractors at par with waiver received from the railways is under process, my lord. Now, I would like to come to Annexure A. Of my affidavit in opposition, my lord. If my lord may come to page 25, my lord.
Yes.
This is the fixation of damages charges against the contractor for the month of December 2021. The entire bunch has been given of the relevant period at the time of filing of my affidavit in opposition. My lord, on the extreme right side,
Yes.
second column, STC handling transport contractor. Handling transport contractor was Anup Trade.
Hmm.
And then Neela and Bajar, that is my lord FSD Ramnagar, FSD Badarpur. Badarpur is relevant to this case, my lord, because the contractor was to move footprints from in his trucks to the Badarpur FSD, then Meherpur, then Lala. So this particular Salchapara was feeding to 1, 2, 3, 4, 5 FSD, my lord. Now,
Yes, but Mr. Singh, the problem is this charge pertains to, this chart pertains to demurrage charges.
this charge pertains to them. How we calculate, my lord,
Correct.
that because
Correct.
submission has
So,
been.
This charge, this chart demonstrates the entities who come into play while calculating demurrage charges, correct?
Yes, my lord.
So, for the Salchapra siding, only the name of Anup Traders is mentioned, no other name.
He was handling contractor.
Correct.
Yes, because he was the only handling contractor.
Hmm.
And the charge, and it was showing, my lord, there was no such damages imposed upon him because laborers were already always ready at the siding, my lord, railway siding, because he was the handling contractor. That means he used to provide the labor, and labor are always there in the tent, my lord, always
All
there,
right,
my lord.
you complete your arguments, will not interrupt, but there are two broad issues here. Please address this.
My lord,
And we don't have much time. How much time will you take now?
and a minimum half an hour, my lord.
Okay. But you see, this bench is
So what?
There is a limit to avoid.
No, that will not
That's what I can say.
debar you from the.
17th.
17, my lord. Much obliged.
Item 3.
Earlier.
3 minutes, can you conclude? Then what to do?
No confidence motion lordship has already passed because of the interim order.
It's taken on Monday
It could be listed in the admission column.
in the admission column. Interim order passed earlier to continue. Party may not put it.
4 and 5.
The respondents were direct to produce the records of the cases also.
My lord, in one matter, we have received the records, my lord. In other, we are yet to receive the record. My lord, let the matter be come after vacation, my lord.
The petitioner's counsel is present. The learned standing counsel. Assam. Taxation Assam submits that record in connection with one of the case is yet to be received. And therefore 3 weeks further time has been paid for. The prayer is not opposed by the petitioner's counsel. In view of the above, let this matter be listed again in the 3rd week of November as per roster. On the next date fixed, the records shall positively be produced by the departmental council.
Highly obliged.
So, Lordship, this is a part heard matter. Will it be, will the? matter
We'll
be
see, we'll see. The bench may or may not be available.
Item 6.
Mr. Agarwal, after vacation, 3rd week,
After vacation, November 21st.
3rd week as per this. What is next?
Can it be on 9th November? It will be difficult. ये मत एक मिनट किए तो दिया ना
Not in
कोई बात तो ना
What is
I think 21st
15 November,
15
yes yes
15 November as per.
15 is can they were supposed to not file a reply to our but they have not filed. So I have been told that the state will not file anything. So far, my lord, union is concerned, they have raised the objection, they have given a copy to us, they have not filed any affidavit, inspection has come. They say that the same thing, that our registration was done after the year and that it was done at the time of private company and not at the time of LLC. These are the two.
All right, we'll see.
Item 7.
Item 7, who is there in item 7?
After vacation, date may be fixed.
On the prayer of learned counsel for the parties, this matter is adjourned. Hearing of this matter is adjourned and shall now be listed again on 16th of November.
Obliged.